So moving on, our next speaker is a senior lecturer and researcher at Department of Business Law, Lund University School of Economics and Management. He is specialized in IT and intellectual property law, especially in the dynamic interplay between policy and law in relation to new technologies. So give a very warm welcome to Johan Axhamn.
Thank you very much. Thank you very much for the introduction, and also thank you very much for the invitation to give my perspective on this highly contemporary topic. A battle royale was part of a title in the newspaper The Economist a few years ago. A battle royale is a battle where only one will survive. This is the question of copyright and artificial intelligence is the most intensively debated and discussed topic in copyright at the moment, in policy making at national level, policy making at European level, policy making at international level. And the background is, of course, that there is a purpose for why we at all have copyright protection. Copyright protection serves the purpose of, say, stimulating and rewarding authors and stimulating and rewarding human creativity. And the main challenge with some of these services, the AI services, is that they, to at all be able to function properly, they need to be trained on existing copyright protected content. And to a great extent, these services have not asked for permission, so they have trained and been developed without permission of the authors. So there is a potential free riding on human creativity, which I will come back to later on in my presentation. There are, of course, sometimes this technology is described as a disruptive technology, a paradigm shift, or even as an apocalypse. It depends on perspective. But just the other day or this morning when I took the train to Lund University, I had some teaching activities there this morning. I read the newspaper that several Swedish artists have joined together with artists and composers and creators from all around the world and joined a petition that this is something really challenging for us, this, say, free riding on our creativity, that what we have created is used as training data, and then someone else can create very nice output that maybe meets a demand in the market even, but still is a free riding on human creativity. There are, say, two main aspects when it comes to copyright and AI. One is the input question, that is to say, what I have mentioned and related to as using existing copyright protected content as training data. There recently Swedish copyright legislation and also European copyright legislation has been updated to some extent. Maybe there are cases going on, court cases on this, but those new rules might be used to permit the use of existing copyright protected content as training data. But this is still it has not been decided by the courts yet, but we will go through some of these provisions. Then, of course, we have the question of whether the output, if someone uses an AI tool to, say, generate. I would like to avoid using the notion create. I can say generate, because the question is who is actually being creative here? Is it the AI or is it the one who is texting the prompt? That's a specific question on whether the output at all in itself can be protected by copyright. And that was the issue that got most of the attention when these tools were developed. But at the moment, that's quite settled how to assess these type of situations. It seems that in most cases there will be no copyright protection for the output. The AI is more as a not similar to a tool to connect what the previous speaker said, but rather something that is quite autonomous to human creativity. But we will have a closer look at that question. There are, of course, different tools for different areas. One of the, if you want to listen to some AI-generated music, you can, for example, listen to Aiva. There are more services than this, but this is one, and one of the first ones. If you listen, it sounds a little bit like background music to a movie, I would say. So it's classical music, a little bit bombastic, but you can listen to it, but maybe not the full human nuances that I would prefer. But it's available on Spotify, for example. There are playlists with Aiva. Then some of these services related to images, those are the services that have got most of the attention. And but at the same time, it's those services that are at the moment subject to court proceedings. Most of these services, one of the most famous ones is DALL-E, but there are others such as Midjourney and Stable Diffusion, etc. Not a single one, anyone out there. But they have been trained on existing images and illustrations, etc. And in most cases, without the consent of the ones who have created these images in the first place. One of the first instances, and I saw that the previous speaker also referred to this situation, this image was generated by using an AI tool, and then the artist won a competition, and then afterwards said, oh, by the way, I created this by using an AI tool. And then the question appeared, and it was also highlighted in the media whether this at all should have been rewarded the first prize of this competition. But of course, it depends on the purpose. Is the purpose to reward human creativity, or is the purpose to create the nicest picture? Maybe that is no longer the same thing. Within the EU, we have not yet any, say, guiding case from the Court of Justice of the European Union. So I will take one example from the US Copyright Office. It is possible in the US to register if you have taken a photo or created an image or something else to register your copyright. It's not necessary for obtaining copyright protection, but you get a little bit more, say, you get access to more enforcement measures if there is an infringement, etc. Such as, yes. And these images were then handed in to the US Copyright Office, and there was a request to register this as a copyright protected work. And the US Copyright Office made the assessment, and I would say that this is very much in line with the European approach. The requirement for copyright protection in the US, the requirement of originality is very similar to the requirement of originality here in the EU. So you can, say, use this case as a inspiration or understanding of how a similar situation would be assessed here in the EU. And the US Copyright Office, of course, identified that copyright protection depends on whether AI's contribution are the result of mechanical reproduction or if it reflects the author's own mental conception. And the answer has to be provided in each and every case, depending on how the tool has been used. But most instances would result in the same assessment and as in this situation, that there is no copyright protection, because AI is the one who has the most creativity in the end result as compared to the human. There is a leading case from the Court of Justice of the European Union. I refer to it there at the bullet point at the bottom, which indicates a similar type of assessment when it comes to protection based on originality. So the question from a copyright perspective is the AI autonomous or is it a tool? And this is very much dependent on the specific situations. But the way that the current services, the functionality of the current services is that the individual texts a prompt, and then based on that prompt, the AI generates an image or similar, and then you can provide further feedback to the tool, etc. But in most cases, that will not be sufficient human input to obtain copyright protection for the end result, because it's the AI that is responsible for the creativity. So this means, coming back to also what the previous speaker was referring to, that I would like to prefer if we in this situation we're talking about AI generated rather than AI created output. Then, and this is the question where you have most of the court cases at the moment. Using existing copyright protected, it could be texts, it could be images, it could be illustration, it could be photographies or something else. Two of the most highlighted cases is Getty Images that has sued one of these services, and the claim is that the service has used these images without the permission of Getty Images. There is another case going on in California, but we also have cases all around Europe related to the training of AI based on existing images. The starting point from a copyright perspective is that the author is provided the right of reproduction. That is the core of copyright, the possibility to control making copies, or reproduction, which is the notion used in copyright. And the definition of reproduction is very broad. It includes not only, say, tangible or permanent copies, but also temporary copies. And temporary copies is the copies that are carried out when existing images, texts, etc. are used as training data. Even if it's a very brief, just scanning through the images to recognize certain patterns, etc., that would be normally deemed to be a temporary form of reproduction. So from a copyright perspective, this is something that the author should be able to control. And by giving this right to the authors, then they can request permission, they can request a remuneration if someone wants to carry out an activity which constitutes a reproduction. But quite recently, within the EU, a new provision on text and so-called text and data mining was introduced. There are two provisions on text and data mining in the most recent EU directive, one taking aim at text and data mining carried out by, say, libraries and research institutions, etc. But then there are also a general text and data mining provision. And the question is, of course, what's the scope of text and data mining? When the directive was negotiated, it was understood, or most people understood text and data mining, taking aim at some researchers that want to search through large collection of scientific articles to find certain patterns in the say quantification of the number of times that a certain word appears in scientific articles, etc. But the definition of text and data mining is so broad that it could possibly cover the situation that a work is used as training for the development of AI. But this is where we have some of the cases in the European Union taking aim at what is the concrete interpretation, concrete scope of this definition. Here you have the general provision on text and data mining. So it says that anyone can carry out text and data mining related to existing works if those works have been made available lawfully or are lawfully accessible. Then the question appears, of course, what's lawfully accessible, but it could be the situation that the work is accessible via license to an online database, but it could also be the situation that the work is just freely made available online with the consent of the author. That could also be lawfully. But there is a possibility to opt out, as you can see in the highlighted bold text there in bullet point number or in paragraph 3. And this is the interpretation of that is what is discussed among copyright stakeholders at the moment. Because many authors and their representative organizations, they deem that it was not the intention of the limitation on text and data mining to permit the use of existing works as training for the development of AI. The intention was to, say, use text and data mining to quantify, say, patterns in scientific articles or collections of scientific articles, but not to use it as possibility to use existing copyright protected content as training data for the development of AI. And we had a discussion the other day in the Swedish Copyright Society, and one of the stakeholders there said that, oh, it's like currently it's like a Mexican standoff. Everyone is, it's difficult to reach any kind of trust or movement between the actors in the market. And then we are, of course, talking about the individual authors, their representative organizations, but also, say, the developers of these tools. So to sum up, of course, we could have the scenario that we, say, do nothing. No update to the current copyright framework. That will lead to a situation that we have a lot of output in the market, available in the market, that looks like it is copyright protected, but it isn't. Because if you make this assessment based on the requirements for copyright protection, then the assessment will be that this does not fulfill the basic requirement of originality. It does not reflect human creativity. It reflects something else. We could also, which is point number 2, sometimes put forward by, say, non-lawyers, that, oh, maybe we could create a new legal personhood for the AI and so on, but that creates all kind, it's like opening up Pandora's box. Bullet point number 3, maybe we could extend the criterion of originality to include, say, AI-generated content, but then it boils down to what is the purpose of copyright? Why do we at all have copyright protection? Is it to stimulate and reward human creativity, or is it something else? So with this, thank you very much.
Thank you. And Johan, please stay on stage with your microphone on for a short while, and we will invite Laura up as well. And I have some questions for you before we go on a short break. So you mentioned that we are some kind of in a Mexican standoff. But how do you see the ongoing development of the copyright and AI? Is this a slow process or fast process?
I think it was a mistake to adopt this new provision on text and data binding because it doesn't have the support of the authors. So they were taken by surprise, and it's also my understanding that many of the EU member states were caught by surprise. They didn't understand that this was actually what they agreed to when they adopted this new EU legislation. So I think that was a mistake, but I think it's very difficult to change EU legislation. So most discussions nowadays is taking aim at, how can we standardize the possibility for authors to opt out? Because then we would say bounce back to the situation that they have to give their permission, and then when they give their permission, then they can ask for remuneration, and then you are within the ecosystem of say, the purpose of copyright. But this is where the different stakeholders are taking a position at the moment, as far as I understand.
Yeah, thank you. And Laura, I wonder, from your point of view, would you say that AI is a blessing or a curse for creatives?
Yeah, it's a great question. One
it's
I've
not an
been
easy one.
thinking about a lot. And first of all, Johan, thank you so much for your talk. It was really interesting. A blessing or a curse? I think, like I said, I'm kind of trying to avoid the extremes when it comes to generative AI because I think a lot of us have some emotional valence around these technologies, which is very, very fair. But I'm trying to keep my researcher brain focused on like the reality of the situation, which, like I said, is that it is a tool and it's probably not going anywhere. And so we need to learn to adjust to it, but that doesn't mean that we have to use it. It also means that we can use it for good, positive, exciting options. So I'm hoping it's neither a blessing nor a curse, but it is a new development. Let's say it that way.
Yes. Thank you very much to the both of you. Give them a big applause again. Thank you.